Their SOPs.
Well, Mr Chairman, in reply to that last aside from the Minister, we just had the extraordinary sight of the Minister and the Chair during the only effective time that this legislation is going to have scrutiny from the House, because his own amendments are not going to be ready for another 45 minutes, partway through the debate, in fact, toward the conclusion of the debate, reading through amendments that the opposition has put up to try to improve this legislation and then reject them all. Yeah. Well, sir, that Minister needs to reflect on the adequacy of the process here. This is legislation that is going to allow him to overturn any planning decision, revoke or amend any resource consent, force councils to allow any resource consent, compulsorily acquire property without any public interest test, demolish any house even if it's undamaged, and dissolve elected bodies if they fail to do what he says. So this opposition makes no apology for wanting to make sure that the legislation is properly scrutinised. And sir, I won't have it said by any member in this House that it is unpatriotic or irresponsible to do so. Our job, the thing that the people pay us to do, is to work out whether the laws that this House is passing are properly made. And it is not an inappropriate exercise of anyone's time in this House to make sure that that is done. And this is not a process that complies on any view with that test, sir. Sir, I'm the chair of the Regulations Review Committee. We are the committee that's had the job of scrutinising the orders in council that are made under the 2010 emergency legislation. And I'm going to acknowledge a point that Amy Adams made. It is true that the orders in council that have been made to date, recommended by the officials and by the Minister and the Chair, have been moderate. And that is an appropriate thing to put on the record. There hasn't been an attempt, generally speaking, to overreach the powers that the Minister has had conferred on him by this Parliament to date. And I'll put that on record happily and freely. I'll also put on record that the Minister didn't have to agree to a select committee process. He could have just ran this all through in urgency. Thank goodness he didn't, because I think all members on that committee would agree we have managed to make some improvements to the legislation. It is a good thing that we had that process. I wish we weren't now at the point of a log jam where we're 40 minutes away from even seeing the detail of further amendments that are to be proposed by the government, but I accept that we have had a summary of those amendments, and that is what I want to take the time to respond to in a couple of detailed points. First of all, sir, Clause 70, and this is a matter that was pointed to by the Legislation Advisory Committee. The test for the making of the orders in council are not that they're necessary. So it's not that we can suspend a law or extend a law or do away with the provisions of a law because they're necessary for the purposes of dealing with the emergency. They can be expedient. So Parliament's saying to the executive here, we're going to actually do away with our right to make laws here. We're going to delegate that to you if you think it's a nice idea, because that's what, in layman's terms, expedient means. That can't be a wise thing to do. The Legislation Advisory Committee cautions against it, and sir, I add my voice to their caution. And I would urge the Minister, even though that's the test that's in the existing legislation, even though he hasn't abused it, and I put that on record, why have the expedient test there? Why not only do away with Parliament's right to legislate exclusively, confer it on him and then say he can do it whenever he thinks it's expedient? It's unwise. It's too broad. We'll regret this precedent in the future. The second point relates to Clause 73.2, and this relates also to a submission made by Professor Joseph. What the Minister can do is make recommendations about what an order in council should say. And what the legislation says is no one can take judicial review of that recommendation, no matter how wrong it might be, no matter how based on incorrect considerations it might be, how unwise it might be. Now, I want to say two things about that, and again this echoes concerns, Mr Chairman, by the Legislation Advisory Committee. First of all, no one's going to bother going to judicially review a recommendation. They'll wait till the order in council's made and then judicially review that. So the powers are necessary. And it's also provocative, sir. That's the second thing. The courts are jealous of their powers, and they're jealous of those powers for good reason. They exist as a bulwark against tyranny, against encroachment on people's liberties by the executive, by the legislature and by other parts of government. Why provoke them by saying, you can't even review a recommendation that I make? It is a foolish provision. It should be deleted. And linked to this recommendation from the Legislation Advisory Committee is that once a regulation is made, it is also attempted to be put beyond judicial review. Now, sir, this absolutely disturbs a fundamental principle that we have in our laws. Any activity by the executive is able to be looked at by the courts to consider whether or not that action is lawful. They can't review legislation, statute, but they can review regulations and orders in council. And there's a very, very good reason for that. Orders in council are made without parliamentary scrutiny, or without much parliamentary scrutiny, and certainly not beforehand. It is a fundamental check and balance in our system that the court should be able to look at the legality of executive action. And again, two things to be said here. First of all, why are we asking it? Why not, if we're confident that the Minister will use his powers wisely, let the courts have the option of agreeing or not? And secondly, again, why use clumsy language as we see in this bill? There's an attempt to oust the jurisdiction of the court, but it's done badly. It's ineffective. And, sir, the worry I have here is we have a line of cases already in this country, enunciated mainly through statements from the former Lord Cook of Thorndon, a former President of our Court of Appeal, a former Law Lord, saying that if this Parliament seeks to put in place, courts will have to think carefully about enforcing those arrangements. Because if they do, for example, agree that executive action should be put beyond the scrutiny of the courts, or they do agree that Parliament should just delegate its lawmaking power to ministers, then the courts would have to think carefully, in the words of Lord Cook, whether they were acquiescing pro tanto in a revolution. Now, do we really want to provoke the courts in this way, particularly with badly drafted probative clauses? I say no, there's no need for it. It's provocative and it should come out of the legislation, sir. So the next point I want to make relates to Clause 29 and also to Clause 30, and it echoes a concern from the New Zealand Law Society. Sir, this relates to the information privacy principles and the way that information will be shared between agencies. Now, sir, the bill would basically require the Chief Executive of SERA to consider applicable privacy principles, but not to protect the privacy interests. So this again is going too far. The Privacy Commissioner has already relaxed the information privacy principles in the way that they apply to Canterbury during the emergency. There's no need, and that's the proper way to do it. The expert who's charged with administering the Privacy Act should be the expert that decides if a relaxation is justified in a certain time in a certain place. And that's what she's done. It came to the Regulations Review Committee. We said, yes, that's actually a practical thing to do in the circumstances, and we've supported it. There's no need to also let the Chief Executive of SERA off the hook in terms of the privacy of individual citizens. Why should that person, and by extension the Minister, be able to ignore all our privacy laws in respect of the people of Canterbury, in respect of the current emergency, without any regard for the expert opinion of the Privacy Commissioner herself? So the next point I want to make relates to Clause 83. This is a clause that would retrospectively validate any action taken in respect of the emergency. Now, sir, again, there's just no need for this sort of broad provision. At the moment, under the state of emergency that exists, there's wide validation of actions taken on an official basis under the Civil Defence and Emergency Management Bill. So, sir, there's no need to duplicate this. There's no need, Mr Chairman, I'm aware that you gave the Minister 3 calls, and I've just got one more point I'd ask your indulgence to make.
Oh, you make it hard. Well, the member has had now exactly the same number of calls as the Minister has had, and we haven't had Mr Locke who's seeking a call, but I'll give you a call.
Thank you, sir. I will
Spirit of generosity.
I applaud your wisdom as always, sir. I only want to make 2 more points. One relates to just to finish that point, there's no need for retrospective validation. The power exists already. Why this headlong rush to do things that will create bad precedent for the future? It's just inexplicable, and the power is not necessary. It shouldn't be done by this House. So the final point relates to appeal rights. This is in respect of Clause 67 and 68. Clause 67 provides that there's to be no right of appeal from decisions of the Minister, except as provided by the legislation. Clause 68 then goes on to provide a very circumscribed way in which appeals are to go through the court system. They go to the High Court and then snap, with certain time limits put on by the statute, they're to go to the Court of Appeal. 2 things again to say about that. First of all, in respect of a lot of these matters, the Environment Court is the expert court that should be hearing these issues, not the High Court. And Ruth Dyson has put up a supplementary order paper that would provide for that to occur. The Environment Court could sit with expert assistance from a valuer, for example, if it was deciding issues of compensation. Now, why not let the expert court do its job? It could probably do it more quickly than the High Court. I know a little bit about the staffing of the High Court in Christchurch at the moment and the personnel on the court. Probably the Environment Court could do it quickly if that's what we're concerned about. The High Court, I think, is in a more difficult position. And then you've got the right of appeal to the Court of Appeal anyway, so there's no need for concern about the law not being applied in anything other than an orthodox way. And so the final point relates to this restriction that we've put, or that the bill would put, onto appeal rights. So there's no need for this. Again, Parliament shouldn't be interfering with the way the rules of court are set out. If what we want to do is say, don't appeal vexatiously, don't prolong matters through litigation, then we could simply rely on the powers of the courts that exist already to do that. We could bolster those powers through the legislation itself, but there's no need to write out appeal rights that could actually negate many people's rights to go on and get legal matters tested, because there are complex legal matters in this bill. And I'd be very disappointed, sir, if Clause 68 survives in its current form.
Keith Locke.
Thank you, Mr Chairman. It's